The committee will come to order. Good morning. And before I recognize myself for a brief statement, I do want to welcome Senator Sheldon Whitehouse from the state of Rhode Island, who is with us today to testify regarding the Home Affordable Modification Program. This is a hearing that, this is the continuation of a hearing that started either last week or a week before that, and we had to call it off due to votes, a long series of votes. And so I appreciate the second panel members for coming today. We'll first hear from Senator Whitehouse, and Senator Whitehouse is very busy over in the Senate and doesn't have a lot of time. So without any further ado, I'd like to recognize him. He has, for more than 20 years, championed healthcare reform, improving the environment, solving fiscal crises, and investigating public corruption. As chair of the Senate Judiciary Committee's Subcommittee on Administrative Oversight and the Courts, Senator Whitehouse has been a fearless consumer advocate on various issues, particularly in the area of helping homeowners save their homes from foreclosure. We very much look forward to his comments and appreciate his contribution to today's hearing. Would you begin, Senator?
I'll gladly do that, Representative Johnson. I thank you for the opportunity to testify. Ranking Member Smith, members of the committee. Sadly, the foreclosure crisis remains unabated in my home state of Rhode Island and many other parts of the country. And I appreciate that you have convened this hearing in the final days of the 111th Congress to inquire into this issue.
And Senator, would you pull that microphone up just a little closer? Thank you.
And I look forward to working with this committee on legislation next year. In my capacity, like yours, Representative Johnson, as chairman of the subcommittee on administrative oversight in the courts, I've chaired several hearings recently on the foreclosure crisis, most recently in late October. At that hearing, a constituent of mine, Larry Britt from Riverside, Rhode Island, told a story that is probably familiar to this committee. Larry had applied with his mortgage servicer for a mortgage modification under the Obama administration's Home Affordable Modification Program, which we call HAMP. And shepherding that request had become for Larry a nearly full-time job. Time and again, over a 19-month period, the mortgage servicer asked Larry to submit and resubmit and resubmit document after document. Despite Larry having FedEx and facsimile records proving that he'd already submitted those documents, the bank consistently alleged that Larry failed to send in the necessary paperwork, and he had to do it over and over again. When he tried to clear things up over the phone, he was punted from department to department, never once during his 19 months of many calls reaching anyone who appeared to have any authority to make a decision. After 19 months of this bureaucratic nightmare, the bank finally approved Larry for a mortgage modification. The modification papers came to him via FedEx just one day after a bank representative had told him that he didn't qualify for a modification. While he's cautiously optimistic with those papers in hand, he still isn't certain that the bank won't change its mind again. Larry's story and thousands more like it get to a story of bureaucracy run amok at the very heart of the foreclosure crisis. Mortgage companies unwilling or unable to efficiently evaluate modification requests, homeowners and mortgage investors in limbo, suffering the consequences. When the paperwork runaround leads to foreclosure, a family loses its home, neighbors lose property value, communities lose tax revenue. Investors who purchase the right to the mortgage payments may lose out too. Often, the foreclosure is not necessary. I met with a group of Rhode Island realtors the other day, and every single one sitting around the table had the same story. Each one of them had had at least one short sale nailed down with a buyer and a seller, and it had the experience of a foreclosure notice appearing and interrupting the short sale. Obviously, that was a worse outcome for the homeowner. It was also a worse outcome for the investors, because the result from the foreclosure sale was worse than the outcome that had been agreed to in the short sale. In the age of securitization, the servicer merely serves as a processing agent and may not work in the interests of the people who actually own the mortgage. And in the age of corporate bureaucracy, the left hand may not know what the right hand is doing. While the program was well-intentioned, the poor performance of the HAMP has demonstrated that cash incentives alone won't get the banks to operate effectively and in good faith. A different mechanism is needed to ensure compliance. In the past, I'd focused on proposals to give bankruptcy court judges the power to reduce the principal on primary residence mortgages, the same way they can for other mortgages on vacation homes, on loans for cars and boats. While I've long believed that this is the most efficient and least costly way to keep families in their homes, and many observers agree, the large banks have fought against it with their full lobbying might. Despite House passage of cram-down legislation in March of 2009, for which I thank and applaud you, we in the Senate have been unable to overcome filibusters. Given these political realities, I decided to add to the focus of my subcommittee a different approach, already underway in several bankruptcy courts. Under programs adopted in bankruptcy courts in Rhode Island, New York, Florida, and Vermont, the court may order the homeowner and the mortgage servicer to sit down and negotiate in good faith, a settlement that is preferable to foreclosure for all parties. While judges have the ability under the programs to appoint a formal mediator if the informal talks don't work, in practice it has not been necessary in the vast majority of cases. For most homeowners, the mere chance to speak directly with their mortgage company, with someone who has some authority, is enough to lead to a mutually beneficial agreement. Under the bankruptcy loss mitigation programs, the power of the court to compel good faith talks breaks through the bureaucratic maze of the voluntary modification programs. The court, of course, does not have the power to force a settlement, but it can force the parties to talk to each other. And that can avoid a costly foreclosure that will benefit no one. The programs in Rhode Island and the other states were designed with the input of creditors and homeowners and have been successful to date. I believe that the courts have appropriately implemented these programs under their Section 105D authority to convene pretrial status conferences. Unfortunately, one servicer has challenged the authority of the bankruptcy court in Rhode Island to require it to come in and talk to the homeowner before it forecloses on their home. I have no doubt that the court's authority will be upheld eventually, but it could be years of litigation and appeal before the parties have a final answer. In the meantime, other judges around the country may be reluctant to adopt a program facing such a challenge. I have proposed a simple legislative fix that would clarify that bankruptcy courts can run foreclosure loss mitigation programs, can make parties talk with each other before someone's home gets taken away. I hope that this committee will help me pass it into law early next year. It seems plain and non-controversial. The American people are tired of taxpayer bailouts for banks, and we owe it to them to support a sensible program that comes with zero cost to the taxpayer. Bankruptcy will not be the answer for every homeowner, but the loss mitigation programs can help homeowners like Larry cut short a stalled application process and finally get an answer to their modification request. One could even imagine that the good sense of this could cause it to propagate outside of the bankruptcy process on a voluntary basis. In Rhode Island, bankruptcy court loss mitigation has already saved 100 homes, and it has the potential to save thousands more across the country. I believe that makes it worth supporting. Once again, thank you for the opportunity to take part in this hearing, and I commend your good work. Thank you, Mr. Chairman.
Thank you, Senator, and thank you for the legislation that you just mentioned. I think it's good in the judicial states, foreclosure judicial states, but there are about half the states almost that suffer from a non-judicial foreclosure process, states like Georgia, where I hail from. And I'm looking at some legislative solutions to that process some federal legislative solutions to that process, which should measure up well with your efforts.
Mr. Chairman, in states like yours and mine, which are both non-judicial foreclosure states, the ability of a homeowner to seek bankruptcy protection in order to stop the foreclosure and resolve all of their credit issues at the same time is facilitated by this proposal. So it's effective in Rhode Island, and I think it would be effective in Georgia as well, notwithstanding the non-judicial nature of your foreclosure process.
Certainly. Thank you.
Thank you, Chairman. Thank you all for your courtesy.
Thank you for your appearance today. And now we will call for the second panel. And I will now recognize myself for a brief statement. These are challenging times in America. Our economy is struggling during an unprecedented housing crisis, a crisis that is devastating American families and neighborhoods. Too many constituents have contacted my district offices for assistance because the banks and lenders are losing their paperwork, failing to respond to their requests for modifications, and failing to return their calls in a timely manner. Their lives are disrupted and turned upside down by the foreclosure process and by the shoddy procedures. The same bankers who came to Congress with hat in hand demanding a bailout, the same bankers who couldn't have survived without welfare paid for by the American taxpayer, those same bankers have no problem summarily throwing the American taxpayer out of her home without due process, without accurate documents, without regard for the human beings whose lives are being affected. So I submit to our friends from the financial industry that our constituents, your borrowers, are living human beings. They have blood flowing through their veins. They care about their loved ones. They agonize over what will happen to their homes. They need to be treated fairly during the foreclosure process. One of the major causes of this foreclosure crisis was greed. Banks and lending institutions, fueled by greed, put everyday, hardworking Americans into mortgages that they knew that these Americans could not afford. In last week's foreclosure hearing, we had a chance to hear from a judge who has presided over more than 1,000 mortgage cases. He testified to the many problems he sees time and time again in his courtroom, including situations where lawyers representing mortgagors failed to know who they represented, or they lacked the underlying note evidencing their entitlement to seek foreclosure, or they failed to establish the legal chain of title, establishing the standing of their client mortgagors, and they submitted to the court, in some cases, false affidavits attesting to the ownership and the note of the mortgage. Recent press reports indicate that lenders have executed foreclosures recklessly and without adequate review of relevant documents. The practice of robo-signing, where lenders sign foreclosure documents with little or no knowledge of the contents of the documents, calls into question the legitimacy of hundreds of thousands of foreclosures. Other problems rampant in the foreclosure process range from the imposition and collection of improper fees, poor underwriting and improper servicing, not to mention the pervasive predatory lending that set the stage for the crisis in the first place. These are serious issues that do not appear to be isolated incidents, but rather a systematic problem within the foreclosure industry. Since 2007, Americans have lost nearly 6 million homes to this foreclosure crisis. This issue is of the utmost importance to me because my home state of Georgia ranks 7th in the nation for foreclosures. Foreclosure and predatory lending issues have always been crucial issues to me. As a DeKalb County Commissioner, I authored and passed Georgia's first approved ordinance against predatory lending, which state legislators later used as a guide in passing a statewide law. As foreclosures continue to surge, we must ask if mortgage services are doing all that they can to provide sustainable alternatives to foreclosure. How can we ensure that servicers have the training, personnel support, and judgment to properly service loans and interact with customers to avoid foreclosure? This is a time of economic and financial instability, and at the very least, families should be able to go to sleep at night knowing that they have a place to lay their heads. Unfortunately, many Americans live under the shadow of imminent foreclosure and struggle against servicers who are often incompetent and disinterested. I thank the chairman for all of his hard work on this committee during this Congress and for taking the time to hold this hearing. The chairman had to depart for another very important meeting, and he asked me to chair this full committee today. I look forward to hearing from the witnesses today, and I yield back the balance of my time, and will now recognize the ranking member of the Judiciary Committee and soon to be chairman, my friend Congressman Lamar Smith from Texas.
Thank you, Mr. Chairman. Mr. Chairman, I was interested in your opening statement because I didn't realize what you had done in the Georgia legislature to help address this problem, and that is much appreciated, and I was glad to hear you say that a state law had been the result of your efforts. Mr. Chairman, let me thank the witnesses from the second panel at our last hearing for their patience and for coming back to testify this week. I regret we were unable to hear from you the last time, but appreciate your effort to be here today. Errors in the foreclosure process are inexcusable and undermine the rule of law and the due process rights of borrowers. However, there does not appear to be any evidence of fraud or intent to mislead the courts. Rather, all indications are that the foreclosure documentation problems are limited to unacceptable but curable documentation defects. While the foreclosure documentation issues are troubling and mortgage servicers undoubtedly will be held accountable for their mistakes, the larger problem is how to end the foreclosure crisis. We seem to be caught in an economic paradox between job creation and recovery of the housing sector. As Peter Wallison of the American Enterprise Institute has observed, quote, "The housing industry, which amounts to almost 1/6 of the U.S. economy, has always been the economic sector that led the United States out of recessions," end quote. But at the same time, it appears that jobs are what we need for the housing sector to recover. Analysts at Moody's have noted that without jobs, fewer households are created, and the existing households are unable to afford to buy a home. Unemployment, coupled with a large number of borrowers who are underwater on their mortgages and an overall lack of consumer confidence, is creating a drag on the housing sector. And by all indications, a weak housing sector is constraining the broader economy. So while the mortgage documentation problems that are the genesis of this hearing are important, the more important question is, how do we get the housing sector moving again? At this point, Obama administration programs like the Home Affordable Modification Program have succeeded in spending large sums of taxpayer money, but have had little success at stemming foreclosures. Hopefully, as we move forward, we can establish more effective policies for both job creation and recovery of the housing sector. Mr. Chairman, I look forward to the witnesses' testimony and yield back the balance of my time.
Thank you, Congressman. In the interest of proceeding to our witnesses and mindful of our busy schedules, I ask that other members submit their statements for the record. Without objection, other members' opening statements will be included in the record, and without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. Without objection, the chair will be authorized to declare a recess of the hearing at any point. I will now introduce our second panel. First is Mr. James Kowalski, Jr. He specializes in consumer protection litigation. Prior to entering private practice, Mr. Kowalski served as an assistant state attorney for Florida from 1989 to 1996, where he prosecuted public corruption, sex crimes, and homicides. He's a graduate of the University of California at Berkeley and the University of San Francisco School of Law. Mr. Kowalski also brings the perspective of having practiced in Florida, one of the states like my state of Georgia, which has been hardest hit by the ongoing foreclosure crisis. He has also been on the forefront of the foreclosure documentation scandal. Welcome, sir. Next is Mr. Thomas Cox. He's been a lawyer for more than 40 years and currently is a volunteer program coordinator at the Maine Attorneys Savings Homes Project. The project is jointly sponsored by the Pine Tree Legal Assistance and its affiliated Maine Volunteer Lawyers Project. Mr. Cox brings to this hearing a unique perspective. While he currently represents homeowners facing foreclosure, he used to represent lenders seeking to foreclose. I think his perspective will be particularly interesting on the foreclosure documentation issues that we are considering here today. Mr. Cox received his AB from Colby College and his JD from Boston University. Welcome, sir. Our next witness, Ms. Sandra Hines, has been detained, flight delay, I believe, so she may or may not get here before we conclude this hearing. Next, I'd like to welcome Vanessa Fluker. She's an attorney who practices in Detroit, which some consider to be one of the nation's home foreclosure epicenters. Nearly every day she is in court helping those at risk losing their homes to foreclosure. And she is a leader of the Moratorium Now Coalition to Stop Foreclosures, Evictions, and Utility Shutoffs. Thank you for being here, ma'am. Over the years, Ms. Fluker and Chairman Conyers have worked very hard to have the state of Michigan institute a statewide foreclosure moratorium, and we'll want to hear her explain to us why such a moratorium is needed. Ms. Fluker received her joint MA-JD degree in 2002 from the WSU Law School and the Department of Political Science. Our next witness is Tom Deutsch. Mr. Deutsch, excuse me, sir, is the executive director of the American Securitization Forum. Before obtaining that position, he practiced law in the Capital Markets Department of Cadwalader, Wickersham, and Taft. He earned his BA from Washington University in St. Louis and his JD from the University of Pennsylvania. Welcome, sir. And our final witness is Mr. Christopher Peterson, who is an Associate Dean for Academic Affairs and a Professor of Law at the Quinney College of Law, University of Utah. He has lobbied on consumer lending policy and testified on consumer finance before the U.S. Senate Banking Committee and the White House. He has a BS, an HBA, and a JD from the University of Utah. It won't come as a surprise, but Professor Peterson has strongly divergent views from Mr. Deutsch on the impact of securitization on real property law. So we're looking forward to an erudite discussion from both of these experts. Now, Mr. Kowalski, would you please begin?
Representative Johnson, members of the committee, thank you for inviting us here today to testify on issues relating to the foreclosure crisis facing our country. I'm an attorney practicing in Florida and a member of the National Association of Consumer Advocates. I would like to start my testimony by making a few clear points in follow-up to the regulator's testimony during your last hearing. First, the manufacture of significant documents for submission to the courts is not a recent practice by the servicing industry. It is widespread and long-standing. The use of robo-signers, more accurately called robo-perjurers, where an individual submits testimony under oath in the form of an affidavit relied upon as the primary evidence by the court in evicting the homeowner, where the individual has no personal knowledge whatsoever regarding the substance of their testimony, is not a recent practice by the servicing industry. These abuses of the judicial system are not the work of a few individuals or a rogue outsourced unit of a servicer. The systemic use of manufactured documents and false affidavits is a business model. It has been the business model of the servicing industry for years. I've been an attorney in Florida for 20 years, starting as an assistant state attorney in the 4th Judicial Circuit in 1989. I served as the division chief of the Public Corruption Unit in a county court and as the senior trial attorney in the Special Assault Unit and the Repeat Offender Court Unit. I was also a member of the on-call homicide team, and I put 3 men on Florida's death row. After leaving the state attorney's office in 1996, I entered civil practice and began representing individuals in wrongful debt collection and wrongful mortgage foreclosure cases in the early 2000s. I took my first robo-signer or robo-perjurer deposition in 2003. As a result of almost a decade of handling wrongful foreclosure matters, I've reached 5 general conclusions. First, the servicing industry as a business model is irretrievably broken, and the application of servicing industry procedures to loan modifications, or to that matter, to any issues whatsoever with the foreclosure itself, has been counterproductive. The clearest evidence of this is in the dual-track process, where a borrower who might not be behind at all, who calls his or her servicer to inquire about a loan modification, or wrongly force-place coverage, or a posting error by the servicer, will often end up, months down the road, with one unit of the servicer continuing to deal with what by then is a horrific customer relations issue, while another unit of the same servicer proceeds blindly and mindlessly with foreclosure. The various units of the servicer do not communicate, are not permitted to communicate, and do not even have access to each other's computer systems. At every turn, the goal appears to be the pursuit, churning, and diverting of servicer fees. Examples of everything I will testify about are in the exhibits that I filed with my testimony. Number 2, affidavits and assignments of mortgage filed in mortgage foreclosure cases are, for the most part, worthless. The overwhelming evidence from Florida and around the country consists of proof that affidavits are completed by persons who not only do not read the file, they do not even have access to the critical portions of the file. It is also now evident that assignments are created after the fact in an attempt to show a chain of ownership, and many critical facts in the assignment, such as the date or the assertion of an equitable transfer, are not based on any evidence at all. For example, the date often used by the assignment is the date the file was transferred to the law firm, not the date the servicer purportedly took ownership or the trust purportedly took ownership. I listened to a federal district judge last month describe affidavits as all surface and no anchor. I have never taken the deposition of an affiant or read or reviewed a deposition taken by another lawyer in more than 7 years of this practice where the affidavit itself was wholly truthful. Number 3, many of the mill law firms are overwhelmed by their internal structures and by demands placed on them by the industry, and as a practical effect have complied with whatever they have been asked to do. This includes law firm employees signing affidavits on behalf of their clients, where the law firm employee had no personal knowledge and was acting outside the scope of whatever authority they might have had. Number 4, legal aid groups and HUD counselors are an integral part of the solution and must be better funded to provide support at all levels. Number 5, local counsel, unfortunately, has no connection to these issues. In conclusion, I would respectfully suggest that the major servicers should not be believed when they assert that borrowers are deadbeats and that speeding up the process and rubber stamping MERS is the course we should follow. At some point, we simply have to stop accepting the ever-changing excuses offered by the servicing industry. If we're to restore trust in our institutions, we have to start at some point to reform the servicing industry. The dual-track concept needs to end immediately. Fannie and Freddie need to be incentivized to be part of the solution. MERS needs to end. The servicers do not need a truth bailout to go along with the financial bailout we have given them as a reward for truly abysmal business practices. And legal aid groups and HUD counselors have to be properly funded.
Mr. Kowalski, I'm going to ask that you sum up at this time. I neglected to mention to the witnesses that we, each of you have 5 minutes, as indicated on the contraption in front of you. There's a green, a yellow, and a red light. The green light cuts off after 4 minutes. It goes to yellow, and then it goes to red. So if you would, sir, please.
Lawyers will always say, I just have a few more points, but I do just have a few more points. As members of the National Association of Consumer Advocates, we would appreciate the opportunity to form a bipartisan partnership to confer as regularly as you want with the members of this committee, with your staff, with OCC, with Treasury, and with others to work through the short and long-term solutions to these issues. But at each step, the interests of American homeowners need to be considered first. Thank you.
Thank you, sir. Next, we will have Mr. Cox give his statement. Thank you, sir.
Chairman Johnson, members of the committee, thank you for this opportunity to be here today. I am retired from the private practice of law in Maine, where for many years I represented lenders as well as the FDIC in loan litigation matters. For the past 2.5 years, I have been working full-time as a volunteer with Pine Tree Legal Assistance and the Maine Volunteer Lawyers Project. I have come to know the foreclosure industry well from both sides of the street. At the hearing conducted by this committee on December 2nd, 2010, representatives from Treasury, the Federal Housing Finance Agency, and the Office of the Comptroller of the Currency each said that their agencies first learned of the issues relating to dishonest foreclosure affidavits and other foreclosure irregularities when the news broke in the press in September of this year. Those were stunning admissions. These issues have existed for years now and have been widely known to those of us representing homeowners. There was a massive failure in the regulators' oversight of these servicers. The issues that we are talking about today should have been immediately apparent from any reasonably diligent examination of the servicer's foreclosure operations. Because the time allowed to me to speak is so brief, I am going to address my remarks solely to my dealings with GMAC Mortgage over the last several months. Problems with GMAC Mortgage were first exposed on the public record by Attorney Kowalski in Florida back in 2006 when he was dealing with a quote-unquote robo-signed affidavit from a GMAC limited signing officer that was executed in 2004. So we know these activities go back at least 6 years. The Florida court sanctioned GMAC for that conduct in 2006, but GMAC rewarded its employee, who was the cause of those sanctions, with a promotion. She became the supervisor of GMAC's document signing department, where she is the supervisor of GMAC's current robo-signer, Jeffrey Steffen. It was his dishonest affidavit signing practices revealed in the deposition that I took of him on June 7th that forced GMAC to finally announce a halt in sales and evictions from foreclosed homes on September 17th of this year. Steffen, who signs between 8,000 to 10,000 documents a month, testified on June 7th that when his affidavits state he has personal knowledge of the facts stated in them, he doesn't. When his affidavits state that he has custody and control of loan documents at issue, he doesn't. When his affidavits state that he is attaching true and accurate copies of loan documents to his affidavits, he has no idea if that is true because he doesn't even look at them. And Steffen admitted that when his affidavits contained a signed attestation by a notary public that he personally appeared to be sworn, he doesn't even bother to do that. Furthermore, he testified that his practices are fully in accordance with GMAC mortgage practice and procedures. When GMAC Mortgage realized the damaging admissions made by Jeffrey Steffen in the deposition I took, rather than immediately moving to correct the problem, GMAC sought to cover it up. GMAC sought money sanctions against me personally for sharing that deposition transcript with other foreclosure defense lawyers around the country. They sought an order from the court that it be used in no other case, and they sought an order from the court that it be retrieved from any lawyers from who had received it from me. In the end, the Maine court denied the motion for sanctions that GMAC sought and imposed affirmative sanctions against GMAC for its bad faith affidavit signing practices and ordered GMAC to pay attorney's fees sanctions in that one case alone of over $27,000. Very recent actions of GMAC Mortgage prove that it is not prepared to cease its use and reliance upon these false affidavits. At the hearing conducted by the House Subcommittee on Housing and Community Opportunity on November 18, 2010, Thomas Moreno, the CEO of Alley Financial, the parent corporation of GMAC Mortgage, testified that GMAC is no longer proceeding with foreclosures based upon Steffen's affidavits without first going to the courts and seeking approval to use them. This fall, we noticed that GMAC Mortgage was doing exactly the opposite in Maine and was proceeding with foreclosure judgments based upon those false affidavits. We brought a Maine state court class action against GMAC, seeking an injunction to stop it from continuing these offensive practices. GMAC has vigorously opposed that effort. To prevent the Maine state courts from even considering our request for injunctive relief, GMAC removed our case to the United States District Court in Maine, where the Anti-Injunction Act prohibits that court from enjoining any state court proceedings. In light of these efforts by GMAC to avoid any judicial consideration of an injunction, the District Court ruled just this past Friday that even though we clearly had a right to a hearing on the merits in the state court, that court was powerless to grant any relief. I submit to you that there has been abuse of our judicial systems by the foreclosure industry on an unprecedented and truly massive scale. Economic interests are driving this abuse. Until these perverse economic interests are addressed, until the regulators truly start monitoring these loan servicers, and until the force of the criminal justice system is brought to bear upon the dishonest conduct of the servicers, including more than just the robo-signers, those at higher levels who clearly have been aware of and condoned and ordered this conduct, there is not likely to be enduring change in this industry. I thank you for the opportunity to be here today, and I welcome your questions.
Thank you, Mr. Cox. Next, we will hear from Sandra Hines. Is it Sandra or Sandra? Sandra Hines. Ms. Hines is a lifelong Detroit resident and a social worker. She brings to this hearing her personal experience of losing her family home of 37 years to foreclosure and of being evicted from that home. Ms. Hines has turned those painful experiences into valuable resources that she uses to assist others facing foreclosure. She's been a tireless advocate on other important issues of concern to the citizens of Detroit. We welcome you to the hearing, and we would like to hear your testimony now, if you would.
Thank you.
Thank you.
I want to first thank the honorable men and women here who can make a difference in our lives in America. I lost my family home to foreclosure and eviction, and I don't know if anybody here knows anyone or has had anyone in their family lose their home, but it's an uprooting. We were uprooted. I still have a lump in my throat, hole in my chest every time I think about it, because my mother and father worked real hard to get that house. We moved into 16582 LeSure, Detroit, Michigan in 1970. When we moved into that home, we was the second black family on the block. My mother and them was seeking a better way of life for us and a better environment. We stayed, my mother put a roof on that home. She put in a new furnace. She put in a hot water and cooler heater. She had the porch redone. She had awnings put around the house. She also had, before her and my father died, central air conditioning added to the home. My sister and my father was GM workers. My father worked for GM almost to the day he died. He contacted cancer from working for General Motors in those foundries that was spitting out asbestos and lead and everything else. I'm here to say that we believed in the American dream. Most of the people who have bought homes in America believed in the American dream. Now we're facing the American nightmare. None of us in America would have thought that the government would turn their back on the people and not allow the people to have the kind of help that they need because the banks decided they wanted to trick and rob people of their homes. Now, we can sit here all day. I'm a little disappointed that the room is not full. I don't know, maybe this is a special committee, and this is the only committee that's listening to people that's really trying to save their home. But I wish that every chair was filled in this room so that they can understand the pain that's associated when you lose a home of over 40 years. We moved 40 years of memories in the cold snow, like a day that we had in Detroit where it snowed all day, the ice was covered over. They threw us out in conditions like that. They took my mother's antique furniture and they threw it over in the dumpster. The bailiff stood out there with his gun to let us know that he would take us to jail and kill us if we tried to stop him from coming into our house. It was the most horrible and most pitiful experience I've ever had in my life, to lose a home that I lived in for 40 years. Where do you go on Christmas now? Me and my sisters are divided. We stand in apartments when we always had a home. Where do you go on Easter when you don't have a home anymore? What can we call home now after all the years that my father worked in General Motors and my mother worked for a neighborhood service agency, helping people all her life because she was a investigator for JDO. And my mother, our house was paid for. The part that hurts me so much, my mother told us. My mother said, don't remortgage the home. If you remortgage the home, the bank is going to steal it. She was telling my friends, my young friends, who was first-time buyers, who was buying homes at that time, that was coming to my mother, didn't understand what was going on. And I'm talking about back in like 2004 and 3. They didn't know that this was the beginning of foreclosure and eviction. My mother encouraged them and begged them, don't remortgage your home. A couple of them didn't, and they have their home today because they didn't. The ones that did don't have their home. They experienced foreclosure and eviction just like we did. I just don't know why we have to come and beg people that we put in office to work for us. What has happened to America? I mean, I don't get it. I don't get it why y'all sit here and make decisions over our lives, and y'all can't see that if you throw us out of our homes, we don't have a life. Your life changed. All of you got a home. You got money. You got health care. You got the best insurance that anybody can have. You probably have the best homes that anybody can have. Don't you think other Americans want that too? Isn't that what America is supposed to be about? The land of the brave and the home of the free? The people worked. The people have worked and built America what it used to be. Because America ain't what it used to be no more. My mother used to always say they're going to turn America into a third world country. Well, you just about done did it. Come to Detroit and look at the neighborhoods, how they've been ravaged by foreclosure and eviction. You ride down streets, there's 6 and 7 houses on one block out of maybe 20 houses, 10 on one side, 10 on the other side. 7 and 8 of them 10 have been shut down because of foreclosure and eviction. I don't know where those people are at. I came here to tell a story of the people. Maybe if the people tell the story, y'all get it. Because ain't none of the rest of y'all being able to affect the other ones. I've seen people, the congressmen that have argued on behalf of the people, they get shut down. It's like they not saying anything that anybody else is listening to. So we have to come now, and I'm going to tell you, I wasn't on the roster to come from Detroit. Once I found out that you was having a hearing, I asked my relatives, I asked my friends to give me money to come here. Just so happened it worked out. And on my way here, I missed the first plane. I broke my glasses while I was on the plane. That's where I can't read my statement. But I'm here because I'm supposed to be here representing the American people. And it's not just black people that's experiencing this. It's all people, all of the people in America. America is a melting pot. People come here because they want help. They want to be free. They want to have what we said America was. And even the people that was born here in America, those of us who claim to be Americans, not only are you not helping those that have came, now you're not helping us, the Americans. Why should people have to come here and tell you this? When you see it's millions and millions of people in foreclosure and eviction, don't you want to do something about it? Don't you want to bring America back? It looks like a garbage dump now. Each city from each city, everything is falling down. It's because people stealing everything that ain't nailed down and not doing what the people put them in office to do.
Ms. Hines, I want to thank you so much for your statement.
I'm sorry if I've appeared to be angry, but I am. I'm mad as hell.
Well, I know.
And I thank you. I know it's my time is up. I appreciate everybody listening to me, but the bottom line, and I'm going to close on this. Don't listen. Do something about it.
Thank you, Ms. Hines. Next, we will hear from Ms. Fluker. Is it Fluker?
Yes, it is.
All right. And if you'd pull that microphone up
Is that good?
And cut it on. Is it on?
The light's on.
Lights on? Yeah, I don't think it must be working. So perhaps if you would grab one of the other microphones, that would be good.
Is this better?
Oh, yeah, that's much better.
First of all, I'd like to thank the committee for having this opportunity to come here today to present testimony regarding this very important issue. I, too, like Ms. Hines, is from the city of Detroit, Michigan, who is ranked at the top of the list, we're almost at the very top, in foreclosures leading to evictions because we are a non-judicial state. First, I'd like to address the perspective of the media perception has been that for some reason you have all these massive foreclosures because you have this multitude of people who bit off more than they could chew, who went into homes that just were exorbitant and beyond their reach. This is not true. The majority of people in subprime mortgages are the working poor, minorities, and senior citizens, and that's what constitutes and makes up the majority of my practice. Unfortunately, the scenario is such that these subprime mortgages were marketed and pushed disparately on the working poor, minorities, and senior citizens. For instance, to give a real-life firsthand perspective, my client, Ms. Hart, works every day as a legal assistant. Mother dying of cancer. Has been fighting for 2 years to get a modification with Bank of America, who, by the way, just got $7 billion additionally in January of this year to do that. No go. They're proceeding to eviction on that matter right now. The only reason the eviction hasn't occurred is because there may be some impropriety with the affidavits and documentation. My client, a senior citizen, who was diagnosed with dementia in 2000, who was put in a pay option arm mortgage in 2007, who we're still fighting. Of course, it's his family now, seeing as we've been fighting so long. He died a week and a half ago. My client who has a farm in Michigan, who was put in a subprime residential mortgage, interest only, that not only covers his house, but his whole farm. And they're foreclosing and trying to take the whole farm. Or even more egregious, my client who was in active duty in Iraq, serving his country, comes back, he's in foreclosure. They're like, oh, well, too bad. We can't work with you. We can't modify your loan. This is just a sampling of what I deal with every day, and it is voluminous. And what makes this situation just, in my opinion, outrageous is because after, as we all know, there's the $700 billion bailout, approximately 75% of these subprime mortgages now are insured or underwritten by the government. Why does that become so significant? Because if, in fact, a mortgage is underwritten or guaranteed by Fannie Mae or Freddie Mac, when the banks and lenders throw these people out in the street, they get paid the full mortgage value. That's why it's a bonanza in Michigan. Michigan property values have dropped in some areas up to 70%. So, for instance, I have a client whose fair market value is going between $12,500 and $15,000. Well, the mortgage balance on the home, being the adjustable rate predatory mortgage, is close to $200,000. Guess what? If they're successful in throwing that individual out their home, they don't get the full market value, they get that full mortgage balance. Therefore, why is there any incentive for any lender to work with anybody when they're being paid the full mortgage value? Now, this was really brought to light in a New York Times article on October 18th of this year. The article is about Bank of America, who is a perfect example because it's the same across the board. And it talked about them resuming their foreclosures after the robo-signing issue. And what's significant about that article is because on page 2, it talks about of the 14 million mortgages that Bank of America holds, Fannie Mae and Freddie Mac underwrite one half of them to the tune of $2.1 trillion. Layman's terms, if Bank of America forecloses on all those underwritten loans by Fannie Mae and Freddie Mac, they would make $2.1 trillion. Again, that is why my clients who send paperwork in for modifications 2, 3, 4, 5, 6, 7 times, I turn around as an attorney, send it in 2, 3, 4, 5, 6, 7 times, certified mail, green card receipt. We haven't received a document and moving their house to foreclosure. That is why that occurs. That is why people who go into trial modifications, who have paid 3 months, 6 months, 9 months, take their money, all of a sudden say, oh, by the way, after paying this trial modification for 9 months, you don't modify. Next thing they know, because we're non-judicial, they have a sheriff's cell tacked to their door, and their whole house is sort of the sheriff's cell. This is just getting outrageous. And I challenge this committee and Congress to do this. I believe this would be a very telling statistical aspect, and I know my time is running out. Fannie Mae and Freddie Mac always talks about how many houses they've sold, which is true, because in Detroit you can go buy a beautiful house for $10,000, $15,000. Someone needs to compare the numbers, how much money was paid to the banks for those mortgages versus how much money was made from the sale of those homes. And I can assure you, for Michigan, it will be an outrage, because basically we're bailing out the banks in a silent bailout with these guaranteed mortgages, and there is no incentive to work with the borrowers. Thank you.
Thank you. Mr. Deutsch.
Representative Johnson, members of the committee, my name is Tom Deutsch, and as the Executive Director of the American Securitization Forum, I appreciate the opportunity to testify here today on behalf of the 330 ASF member institutions who originate the collateral, structure the transactions, serve as trustees, trade the bonds, service the loans, and invest the capital in the preponderance of residential mortgage-backed securities in the United States. In my prepared statement, I highlight some of the key aspects of securitization, as well as its critical importance to the U.S. and global economy. Importantly for this hearing, there are nearly 55 million first lien mortgages in America today that total approximately $9.75 trillion of outstanding mortgage debt. Approximately 3/4 of this debt, or about $7 trillion, resides in mortgage-backed securitization trust and are beneficially owned by institutional investors in the United States and around the world, such as pension funds, mutual funds, and insurance companies. But in my remarks today, I seek to address specifically the concerns raised by a few commentators that securitization trust may not actually own the $7 trillion of mortgages that are contained within those trusts. For example, a recent Congressional Oversight Panel report has even suggested that these issues could create systemic risk to the banking sector if loans weren't validly assigned to the securitization trusts. But the concerns that have been raised have not been supported by substantiation that there are in fact signs of systematic fails in the process of assignments. Indeed, the origin of these concerns is not clear. They are not the result of a series of new court cases supporting the legal arguments advanced, but instead appear to be largely the result of novel academic theories. In fact, even the Congressional Oversight Panel report states that, quote, the panel takes no position on whether any of these arguments are valid or likely to succeed, end quote. So all of these dire consequences flow directly and solely from a single mistaken core premise, that is, the trusts and ultimately the institutional investors such as pension funds and mutual funds don't actually own the $7 trillion of loans in those trusts. As discussed in great detail in my written testimony, this core premise is incorrect, and therefore the dire consequences of this faulty premise will not follow. Just last month, the ASF issued a white paper on this subject that is part of our written testimony that puts to rest many of the questions that had previously been raised about the ownership of mortgage loans. In that white paper, the ASF exhaustively studied traditional legal principles and processes, including the Uniform Commercial Code, or UCC, and substantial case history throughout every one of the 50 U.S. states and the District of Columbia, and found that traditional legal principles and processes are fully consistent with today's complex holding, assignment, and transfer methods for mortgage loans. In fact, 13 major U.S. law firms listed in Exhibit A to the ASF white paper reviewed it and believe that the executive summary contained therein represents a fair summary of the legal principles presented. Although the ASF white paper answered many of the concerns that had previously been presented, some new concerns have been raised since that white paper was published. For example, one commentator has proposed that securitizers have not met the contractual requirements for a complete or unbroken chain of endorsement. In our written testimony, we rebut this novel academic theory in great detail, with analysis of key contractual provisions, the intent of the contracting parties, industry custom, independent third-party trustee acceptance, as well as relevant case law and UCC applicability. In particular, this argument overlooks the fact that each separate step in the chain of transfers of ownership by each party from the originator to the securitization trust is fully documented by a separate contract. The proposition itself, though, that securitization legal professionals have uniformly opted out of the applicable laws, such as the UCC, to set an even higher bar for transfers, but then subsequently and systematically ignored that higher bar, appear on their face to be illogical assertions, and ultimately, as the legal analysis in our written testimony demonstrates, are patently false. From time to time, though, mistakes will occur, and they certainly do occur, particularly in a market where 55 million mortgages are being serviced and in the worst housing crisis that we've seen since the Great Depression. But those mistakes do need to be addressed. But the contractual provisions of the pooling and servicing agreement and other underlying documents allow for those mistakes to be corrected over time. In conclusion, the ASF greatly appreciates the opportunity to be here before this committee today, and I look forward to answering any questions that committee members may have. Thank you.
Okay, thank you, Mr. Deutsch. And if the panel will allow me just a couple of seconds to consult. Okay, Mr. Peterson, your testimony, please.
Mr. Chairman, Ranking Member Smith, it's an honor to be here today to testify.
And I believe that mic may not be on. Okay.
How's that? Nope. There. Mr. Chairman, Ranking Member Smith, thank you, other members of the committee. Thank you for the opportunity to testify. If history, the long scope of history teaches us one single lesson, it's this, that sooner or later, the powerful folks in a society are going to come and try and take the land from the less powerful folks. That is an immutable lesson from history, and if you learn nothing else from it, that is a truth about the human species. And I think that that's what we're seeing today. One of the first things that the European colonists that came over from Europe did, before they set up the United States Constitution, before freedom of speech, before separation of church and state, before any of our constitutional principles, all 13 original colonies passed land title recording statutes that established real property records in the control and custody of democratically elected county recorders or county officials. So the people who got to decide who owned the land was the first thing that they set up. And they did that because in Europe, there was an understanding that sooner or later, the rich folks were going to come and try and take the land from the poor folks. And that legacy of certainty and real property ownership has been around in our country for a long time, and it's something that we have come to take for granted. We had that, and many other countries don't. But in the 1990s, the mid-1990s, the Mortgage Banking Association decided that they no longer wanted to pay the fees that were required since the beginning of the Republic to record documents with county officials. So they decided to create a shell company that would pretend to own all of the mortgages in the country. That way they would never have to pay another fee for recording an assignment as those mortgages changed hands in the process of securitization. And overall, this wasn't going to save that much money, but on any given loan, maybe they'd save $200, $250, plus the hassle of recording. And this was, they did this without any permission from the state legislatures or with any appellate authority from appellate courts that said that they could do that. This was a radical and fundamental change in the real property recording system. The name of the company that does this is called MERS, or the Mortgage Electronic Registration System. It's one of the currents in the foreclosure crisis that really hasn't been played out in the press and hasn't been discussed in Congress to the extent that I think it should. And my testimony is going to focus on that particular company. First, I believe that MERS is an anti-democratic institution. It undermines not only the democratically elected county recorders and circumvents the democratically adopted state legislatures' land title statutes, but it also circumvents states' rights by creating a shadow company that's owned by Wall Street banks and insiders and is operated outside of Washington, D.C. without any oversight from the federal or state governments. Second, I think that MERS is, not only is it anti-democratic, it's deceptive and it doesn't work well. Because there's so much legal uncertainty since they created a new legal system without any cooperation from legislatures, it's not clear whether or not their claims to owning mortgages are actually valid or will be ratified over the long term as state appellate courts look into it further. I submit that the MERS system stymies modification of mortgages. Families that are in the foreclosure process oftentimes get a notice from this company called MERS and don't understand who it is or whether or not they can negotiate with that particular company. It makes it more difficult and more confusing for borrowers at precisely the time when they're most vulnerable on the eve of foreclosure. A couple of solutions that I would suggest for the committee to consider. It seems to me that Fannie Mae and Freddie Mac, as well as FHA and the VA and other federal housing finance agencies, ought to stop buying mortgages that are recorded through this exotic and unprecedented system. We still have a legal system that's safe and reliable. Why is the federal government still buying mortgages that are untraditional, recorded in untraditional ways? Not only does it ratify the undemocratically motivated incentives of the financial services industry, but it also imposes risks on the taxpayers because it's not certain how these legal issues are going to be worked out. I'd also suggest to the court or to the committee that we ought to consider some new ideas in trying to incentivize modifications. Here's one. why don't we create a one-time emergency homestead exemption of $15,000 that allows the first $15,000 in proceeds of a foreclosure sale to go to the family as opposed to the servicer? It's a little bit like a compromise between the cram-down legislation that had been considered earlier, but it's much more simple. It would be easy to administer. The first $15,000 in proceeds goes to the homeowner. That creates incentive for the homeowner to not drag their feet and fight out long foreclosure battles, because there's $15,000 that they can spend on getting a deposit on a new apartment and a first month's rent and getting the kids in a new school. Also, it creates some real incentives on servicers and the investors to really get serious about modifying mortgages. And unlike the HAM program, it doesn't cost taxpayers a dime. Congress could do this with its Commerce Clause authority, I believe, and it'd be a real meaningful fuel injector in the foreclosure system that might actually do some good, whereas the current programs are not doing any good and are failing. Thanks for your time.
Thank you, Mr. Peterson. This hearing has released to the public some very spectacularly devastating information about the mortgage industry in this country as it works. Mr. Kowalski, having put 3 people on death row in Florida as a criminal prosecutor, who is now handling mortgage fraud, foreclosure fraud cases, discovered back in 2003 the robocall, the robo-signing phenomena that's been quietly permeating the foreclosure process for perhaps years prior to that time, no telling how long. And then Mr. Cox having uncovered from the master robo-signer, or the current master robo-signer, his practices, which are fully in keeping with GMAC mortgage practices, just devastating. And then Ms. Hines to put the human face on how this drama affects people, real human beings and real families. And Ms. Fluker coming forward with testimony about Fannie Mae and Freddie Mac, and how the taxpayers ultimately are on the hook for the full value of these mortgages, even though the collateral now is not worth the paper that it's written on in some cases. And then Mr. Deutsch having some expertise in how this system works, and Mr. Peterson then coming forward from the early annals of history of America about the importance of title to land to the settlers, how important that was, and bringing us up to date now on how we have how the mortgage industry has sought to evade recording fees for documents, assignments of mortgages, and have put in place this this concept of the Mortgage Electronic Registration System Incorporated. Can you tell us, Mr. Peterson, a little bit more about that entity? And cut that mic on, please.
There we go. The company operates a database. Think of it as a big Microsoft Excel spreadsheet, and members of the system can enter information onto that database about the ownership of the loan or who holds the servicing rights of the loan. But the tricky part that makes it legally problematic is that in order to justify not recording those assignments, that as the promissory note gets transferred to various companies on towards securitization, the mortgages list MERS as the mortgagee on the loan. And the mortgagee, of course, is historically is the same person as the lender, and it's the one who owns the right to foreclose, owns the lien. And it's very controversial, I think, from a legal perspective, whether or not MERS can be a mortgagee, because they don't actually invest in the asset. They don't make any loans. And now 3 state Supreme Courts, Maine, Arkansas, and Kansas, have all held that in various contexts, MERS actually is not a mortgagee. And it creates some real inconsistency with the position of the securitizing banks and the trustees that manage the pools of loans, because they also claim to own the mortgage. They need to do that because otherwise their investors will be upset. As Mr. Deutsch pointed out.
Let me stop you
here. Please, I apologize.
Who owns or who are the participants in MERS? Who are the owners of MERS? And does MERS have the ability to cut through the rigmarole that the attorneys, Mr. Kowalski, Mr. Cox, and Ms. Fluker, have to deal with in terms of establishing a chain of title, if you will? Does MERS have the ability to be of assistance in terms of running that title down? And I'd like to hear from each of the witnesses about that.
Well, it's a great question. MERS is owned by Fannie Mae, Freddie Mac, and also all the big banks, Bank of America, Citi, et cetera. That's who owns it. Can MERS cut through the rigmarole? My answer is no. MERS actually exacerbates the rigmarole. Why? Because MERS is just a shell company. They don't have very many employees, so they have what are called about 20,000 so-called vice presidents. And these vice presidents become vice presidents by getting a boilerplate corporate resolution. I'm using air quotes for the record. Corporate resolution. I'm not sure that it really is that, but they get this corporate resolution off the internet, and these are really customer service representatives, paralegals, workers for servicers that pretend to be vice presidents of MERS, and they're the same people in many cases that were the so-called robo-signers. So vice presidents of MERS are pretending to be, or employees are pretending to be vice presidents of MERS when they go about doing this robo-signing nonsense. So I don't think that MERS has helped clear up the system at all. It makes it more difficult for homeowners to understand what's going on, and it creates confusion and I think even deception in the system.
All right. Thank you. Mr. Kowalski.
If you look to, and I understand you wouldn't have it in front of you, but if you look to Exhibit 6 that I filed with the committee, you will see a MERS assignment. It is an assignment that purports to have been signed on behalf of First Horizon Home Loan. It is actually signed by an office manager of the law firm that is foreclosing in this case. And when I finally received, for example, the purported power of attorney that allowed the office manager to sign hundreds of these without knowing whether any true transfers took place at all, because it's not part of her law firm office manager job description. I received a power of attorney that's also the next document in your Exhibit 6 that plainly makes clear that she doesn't even have authority to have signed the affidavit that she knows nothing about. So in short answer to your question of whether MERS helps make the process more transparent and solves issues for the courts in particular, the answer is clearly no.
Thank you, Mr. Cox.
Representative Johnson, MERS has proven to be a significant problem for us in Maine. MERS claims that it has the right to foreclose mortgages in its own name. MERS has admitted that it does not own any loan. It never has owned a loan. MERS has no right to collect payments on any loan. It admits that, but yet it claims that it has the right to foreclose mortgages. In Maine this summer, we went to the Maine Supreme Court, and we obtained a decision in the case of MERS versus Saunders, which explicitly held that MERS does not have the right to conduct foreclosures. MERS seeks to get around that problem by a subterfuge. Jeffrey Steffen is a MERS vice president in addition to being an employee of MERS. What MERS tells people like Mr. Steffen is that when MERS wants to foreclose in its own name, Mr. Steffen should get out his MERS hat for a moment and put it on and call himself a MERS vice president. And in that moment, he should take possession of the promissory note that belongs to GMAC, perhaps, and hold it in his hand. And at that moment, MERS owns it, they claim. And because of that, MERS claims that from there on out, it can go forward and foreclose. This is a subterfuge on homeowners and lawyers all over the country who don't even know who owns their mortgage and who they should deal with in trying to handle foreclosures and negotiate modifications.
Thank you, and I'll be vacating this seat perhaps during Mr. Dush's, excuse me, Ms. Fluker's response to the question. And I'd also ask you to respond as well, Mr. Dush. And the reason why I'll vacate the chair is because the chairman is back. Thank you.
MERS, can you? MERS is a problem in Michigan as well. As stated earlier, Michigan is a foreclosure by advertisement state. That means it's done statutorily. In Michigan, in order to have a valid foreclosure on a property, you are supposed to be able to show that you have an ownership interest in the indebtedness. MERS cannot have an ownership interest in the indebtedness because if you look at MERS's title on every mortgage, MERS is solely the nominee for the mortgagee. However, because of the changing of hats, so to speak, of the affidavits that are submitted, it has become a split issue in Michigan. There are cases up on appeal right now. There are judges who say, hey, this doesn't make sense. There is no ownership interest. There are others that have said, well, because of the contractual relationship of the mortgage document, that they could have some standing. The bottom line is MERS is merely, as Mr. Peterson said, a shell corporation. If you look at their website, they strictly hold themselves out to be a recording agency. Case law from Nebraska and Kansas has indicated that they do not do any servicing on the loan, meaning they don't accept payments, they don't hold the mortgage. Therefore, it almost seems kind of commonsensical that they don't have an ownership interest in the loan, yet they continue to foreclose independently without stating the actual lender or servicer, which has obviously exacerbated and complicated the foreclosure matter even worse than it already was. Thank you.
In 2010, we have 55 million mortgages transferring through the system. In the 1600s, when our land title property records were created, I can't give any kind of significant detail to that, but I'm guessing we were in the hundreds, maybe thousands of things being recorded. Our complex financial system has expedited the speed at which mortgages move through the system, whether they're originated, the way they're transferred. Certainly a much more complex system. That complex system, though, has enabled a massive increase in home ownership in America over the course of the past 20, 30, 40 years. MERS has played a part of that, just as the securitization process has played a critical part of that to allow additional access to credit. MERS acts as a transfer of the title of the mortgage loan. That is, as an originator originates the loan, they may sell it to a subsequent purchaser, who then may sell it to another purchaser, who then ultimately securitizes it. And by that securitization process, you're able to link the process of originating the loan with institutional investors such as pension funds and mutual funds who are looking to invest money, to effectively lend through the securitization process money from the mutual funds and pension funds directly to homeowners. And MERS acts as a recording agent so that you're able to track the ownership of that mortgage from ultimately the originator to the ultimate investor who owns those loans. The process of doing that allows for the additional creation of credit. Moreover, MERS does act on behalf of the trust, and in a majority of jurisdictions throughout America, it has been found that MERS does have the ability to foreclose in their own name. But in many jurisdictions, or in those jurisdictions that have been cited before, servicers are transferring the name out of the ownership interest out of the MERS name and into the name of the trust, who is the beneficial owner. So this is a question of technicality as to who can foreclose, not to whether foreclosure can occur.
Thank you. Well, thank you very much, Mr. Johnson, for stimulating all of the witnesses to the response. I'd like to now turn to the distinguished gentleman from Arizona, Mr. Trent Franks.
Well, thank you, Mr. Chairman. Thank all of you for being here. Let me start by suggesting, Mr. Peterson, that your opening statement was very compelling to me. You know, there's an old Iroquois quote that says, the secret to the universe is in the true naming of things. Sometimes clarity and specificity are very, very important, and I think that applies fundamentally to property rights. And so I think we have some, and I want to ask you some questions about that in the course of the moment here. But I was also touched deeply, Ms. Hines, by your testimony, and I want to be very careful how I respond to that, because it seems to me that for 40 years your family did pretty well until government came along and kind of messed things up. And I would suggest that Ms. Fluker's comments were also very compelling in that we've created a system because of government's involvement that now we've actually created a disincentive for banks to work things out with the homeowner, because they, for understandable reasons, I mean, we've got a lot of major pension fund people that have contributed, or I should say invested in these things, and we're trying to hold the system together. But the end result, Ms. Fluker is correct, the end result is that because of government involvement here and the lack of market discipline that comes with government involvement that seems to hold the system together, we're in a situation now where banks have an incentive oftentimes to foreclose rather than to work things out with the homeowner. And I think there is something desperately wrong with all of that. It's ironic that when this republic was first put together, one of the comments of the founding fathers was that, when they asked, what have you given us? The response was, well, we've given you a republic if you can keep it. And it seems like that we forget that the founding fathers knew that sometimes government had the power to waste the substance of its people under the pretense of taking care of them. And I really believe that government here, and with all good intentions, has caused a great deal of chaos and lack of specificity and a lack of market discipline that has created a lot of these problems. So in a sense, I'm afraid that government is as much part of the problem as it is any possible solution. With that, Mr. Peterson, if I could speak to some of your comments related to MERS. In your testimony, you actually questioned the legality of the mortgage electronic registration systems. I'm saying that so everybody understands what it is, which, of course, is the MERS system that's been talked about here quite a lot. And I think it's a very significantly important subject, since about 60% of the nation's residential mortgages are recorded in the name of MERS, Inc. And the legality of this obscure entity should be either established or addressed. It seems very clear that this is a big issue. You lay out MERS' dual and seemingly conflicting claims of acting both as agent and principal in mortgage deals, and you describe the incoherence of MERS' legal position as, quote, exacerbated by corporate structures that is so unorthodox as to arguably be considered fraudulent. Well, I have to tell you, I agree with you completely. There's no disagreement here. Clarity here is lacking, and I understand that there was an effort to do something good here, but the clarity was lost in the process. So can you elaborate any more? Is there anything else that you want to say about that you haven't already said?
Well, thank you for the respectful comments. Yeah, I think that I'd like to add that MERS is significantly depriving county governments of revenue, which I think is another potential problem. Nobody likes taxes. I don't like taxes, but if we're going to no longer require or no longer facilitate recording assignments between mortgagees down the chain of securitization, then it needs to be the legislatures that decide that we're going to do that. And also, speaking to the legality issues, there was no state legislature that adopted a statute that said that they could do this. And what's more, they're going to drag up some cases here and there from, this era, that era, saying there's some nominal form of recording that's allowed and you could still successfully perfect a mortgage. But look, there's never been a situation where the facts would arise before an appellate court that replicate these facts. We've never tried to have one shell company try to own all the mortgage loans in the country anymore, so they're not going to find any case that says that that's legal, that a Supreme Court can't distinguish. So the reality is that we're going to have some real uncertainty about whether or not these loans are perfected, and even potentially whether or not mortgage loans are enforceable. And that's something we're going to have to deal with for the foreseeable future.
So you believe that it's kind of become an anti-democratic an institution, and that it has fundamentally weakened or diminished the clarity of property rights itself?
Yes, I believe that, and I think there are increasingly title insurance companies, especially the independent, smaller title insurance companies, are starting to come to that recognition as well. I believe it decrease the certainty of property rights in our country. Property rights are a function of law, right? Law is what creates property rights. And if you have the new oracle, the new definer of who owns something, be an institution that's created by an industry trade association as opposed to a state legislature or an appellate court, in a country that purports to be a democratic republic, you have just introduced all sorts of uncertainty into the system. It's not clear whether or not the structure that they set up without permission is going to be recognized by the courts as legitimate. And that's not just a bleeding heart professor liberal comment. That is a decrease in an economic resource that industry and consumers alike had relied upon. There are a lot of countries out there where nobody knows who owns the land, and so it makes us less likely to invest in the land. It makes us less certain about whether or not we want to start businesses or build homes, because you can't be certain that 10 years down the road some strong person might come and take that from you. We've lost some of that certainty by losing our state and county, the effectiveness of our state and county real property records.
Thank you, Mr. Chairman. If I could just ask Mr. Deutsch to respond to that, because I know that he had some potential dissent here, and I wanted to give you a chance to do that. Then I'm prepared to yield back.
Thank you, Mr. Franks, and certainly for the record, I do have strong dissent with Mr. Peterson's comments. In 46, I believe it's 46 states, the validity of MERS to effect a foreclosure has been upheld by the state judiciary. In a minority of states, in 4 states, I think all 4 of them have been mentioned, there's been some question as to whether MERS itself can initiate the foreclosure. But in those instances, the mortgage loan can be transferred out of MERS name and into the beneficial owner's name, whether that's a trust or another investor, to be able to initiate the foreclosure. So there's very clear legal property right for MERS or any other system to be able to foreclose. There is no question as to the property rights. To the second question and the second issue as to the recording fees, I think there's a very strong reason why we don't want to pay recording fees that don't do anyone any good. Particularly as it pertains to Dodd-Frank, which was just passed, there is a specific provision that does provide the opportunity for any borrower to be able to find out who owns their loan. So that has been addressed in another means in a federal legislation, but I think the critical component for MERS is to be able to allow the facilitation and transfer of mortgage loans in the secondary market system to help keep mortgage loan costs as low as possible.
Thank you, Mr. Chairman.
Thank you, Trent Franks. Interesting line of questioning. Did anyone, before I recognize Howard Coble, want to make any comment about this discussion so far? Mr. Kowalski and Mr. Cox?
One quick point, if I could, Mr. Chairman. With regard to the issue of whether or not MERS is transparent and tracks investors, I've got a MERS screen print from the MERS Service ID system that I printed off last week for another issue. And just as an example, when a HUD counselor is trying to do a loan mod, one of the things they're constantly being told is they need to know what the investor guidelines are. Investor guidelines, investor guidelines. The actual reality is the servicers control everything and the servicers, if they're interested in a loan mod, don't even talk to the investor. But this is a MERS service ID from last week. The servicer's GMAC mortgage. Investor, quote, this investor has chosen not to display their information. For assistance, please contact the servicer. So if you're trying to find out who owns your loan from the MERS system, you can't do it anymore.
Mr. Chairman, with all due respect to Mr. Deutsch, I suggest that he's perpetuating a myth that MERS has been spreading about the country. Maine is one of the first state Supreme Courts to address the legitimacy of MERS' right to foreclose mortgages, and it did so this summer, and it said that they have no right to foreclose mortgages. Almost no other states in their Supreme Courts have addressed the issue. There have been a number of lower-level trial court decisions going both ways. But when Mr. Deutsch suggests that 46 states have blessed the concept of MERS foreclosing mortgages, I suggest that he's not being accurate.
Attorney Fluker, your silence isn't kidding me one bit.
Thank you, Chairman. I definitely would like to address the issue as well. One thing that I think is very important that the emphasis has been on MERS recording, the assignments, things of that nature, but that is what the problem is. Even though, as Mr. Deutsch indicated, well, MERS can assign it back to the servicer who can then foreclose or assign it here or there, but all those assignments are not establishing who has the ownership interest in the debt, who actually owns this mortgage and this loan, and that is the problem. You can go all the way through litigation. I have a case right now. We've been to federal court, we're back in state court, and at the end of the day, we found out when they foreclosed, there wasn't even a deed. There was no chain of title for the ownership of the mortgage, and 6 months after the sheriff's sale, a quote-unquote affidavit of lost deed was filed, signed by the same person who has been the corporate resolution person for a zillion different other companies and MERS. So, I mean, there's questionability as to the legitimacy of that. But that is one of the major problems with MERS, is you cannot determine strictly from a MERS assignment who has the ownership interest in the debt. And when you challenge this, there's no way to track back because MERS is solely a recording agency and is not a servicer or a lender.
The chair now recognizes the distinguished chairman of the Subcommittee on Crime and also a distinguished member of the Budget Committee, Bobby Scott of Virginia.
Thank you, Mr. Chairman. Let me just follow up on that. If a person buys property at foreclosure, who do they buy it from? Mr. Peterson?
It's not clear. The title to the land is still, the fee simple ownership of the land is still deeded in the homeowner, but there's a lien on the land, and the lien is recorded in the name of MERS. Now, MERS has to come and file a release of the lien, but it's never clear whether or not the person that's acting on behalf of MERS, remember, this is not a real employee of MERS, this is a vice president that's an employee of some other company. It's not clear whether or not that person is the appropriate individual to release the lien. So basically, we just have to trust
release the lien is one thing, but I mean the fee simple title, who transfers title?
MERS says that they're filing a release of the lien, and then the homeowner buys fee simple title from the previous homeowner.
Well, the homeowner is being foreclosed on. I mean, they don't sign anything. I mean, if you're doing a title search and you see a foreclosure in it, you see the owners bought the house, mortgage is recorded, next thing you know, somebody else owns the house. Who transferred the title?
In judicial foreclosure states, when there's a sale, the clerk's office transfers title to the bidder at the sale, which is almost always, unless there's any equity in the property, is almost always the foreclosing servicer in Florida. In Florida, typically we see servicers foreclosing in their own names. So when the title transfers, even to make this issue even more confusing, instead of the investor trust transferring, you have the servicer purporting to transfer on behalf of the investor trust through the local clerk's office without any intervening assignments or true transfers being recorded as the headache for the title company down the road. That is the perfect storm of that is in my Exhibit 1, which is where you have two securitized trusts, both alleging they both own the same note, foreclosing on the same house at the same time. So to add a further layer on it,
Two different buyers?
well, it's an active foreclosure, so it's two different securitized trusts through two different servicers, both alleging in the paperwork they filed with the court, and in one case swore to under Florida's recent civil procedure amendments, alleging they each own the same note and are foreclosing on the same house at the same time. I've also cited to a Florida appellate court decision where one of our appellate courts reversed on the same fact pattern to add another layer to this issue of what exactly the clerk is transferring when the clerk in a judicial foreclosure state actually transfers the title.
Mr. Cox?
Representative Scott, a related problem, and again, I have to address some of the testimony from Mr. Deutsch. He described how in some instances MERS will assign a mortgage back out to a foreclosing party other than MERS. I would say in 20 to 30% of the cases that I encounter, when MERS is doing that, and I can give a specific example. We have a case in Maine where a mortgage was granted to MERS as nominee for First National Bank of Arizona. Last year, MERS assigned that mortgage back out to another banking institution as nominee, purporting to act as nominee for First National Bank of Arizona. The OCC had closed that bank a year and a half earlier. MERS had no power to act for that bank at the time that it made that assignment, and it's leaving in its wake a massive title problem all across the country because of this.
I want to get to another issue, and quickly in time I have left, and that is on the accounting principles, whether or not there's something in accounting principles that create disincentives for the banks to work with people. I understand that if there's a short sale, the bank has to realize the loss right then and there. However, if there's a foreclosure, in which case they're going to end up with less money, they don't have to realize the loss according to accounting principles until much later. So if the bank is kind of on an edge and want to keep their books as fat as possible, they're better off going into foreclosure because they don't have to realize the loss rather than a short sale, which is in everybody's best interest, the homeowner, the new buyer, the bank actually. Are there disincentives in accounting principles that we might want to address to encourage people to do what's in everybody's best interest rather than allow the fraud of allowing banks to have on their books assets listed at values that are not realistic?
I would like to take that question first, if it's okay. One of the major problems, as I articulated somewhat but didn't go into detail in my testimony when I began, was that such a large percentage of the loans now are insured by the federal government, Fannie Mae and Freddie Mac. Now, let me be clear. Under the Making Home Affordable program, there is a specific hierarchy of loss mitigation procedures that should be followed. First, you should be looking at the borrower's loan to see if they're eligible for a modification using the formula articulated in their supplemental guidelines, looking at the 31% of the income, things of that nature. If for some reason there is not the financial possibility or feasibility of modifying that loan, you are immediately to go to the next foreclosure alternatives, being short sale and deed in lieu. That, again, just like the modifications, are even less of a possibility from the mere fact. I know in Michigan, you're looking at almost a 70% property decrease. And I would venture to say in other states, even though the property decrease may not be that significant, there is a decrease, so there's every incentive to move forward with the foreclosure when you're getting paid the full mortgage debt plus the foreclosure fees plus the cost plus the attorney fees that the foreclosure attorneys charge to foreclose on these properties.
Wait a minute. On the short sale, the guarantee, the federal guarantee of the loan does not kick in to make the loan whole?
I don't believe it kicks in 100%. There are some incentives in place, but it's much more lucrative because you're getting the full mortgage debt at the foreclosure. At the short sale, the purpose of the short sale is that you're selling the property short of what the full mortgage debt is. Therefore, there is not going to be the same level of profitability. And moreover, the way the structure is set up now, with the way the laws are set up, it is actually much more expedient to send someone out 2 modification letters, tell them you didn't receive their documents, shoot them to a sheriff's cell, which is very simple in Michigan, because Michigan is a non-judicial foreclosure. You don't have to go into court to foreclose on anybody in Michigan. In fact, to show you how bad it is in Michigan and how disingenuous this process is, I have had people that I started representing at the eviction action still getting these form letters from their lender and servicer saying, hey, call us, we can help you, we can modify your loan. Why are they still getting those letters? Is because under the supplemental guidelines of the Making Home Affordable program, they are mandated to reach out with solicitations to borrowers in order to remain eligible for those programs and receive those incentives. So in essence, there's an opportunity to get 1, 2, 3 bites at the apple, and then at the end of the day, walk away with the whole basket because you get paid the full mortgage value on a property that is significantly less than that mortgage balance.
Mr. Cox.
Representative Scott, there are servicer fee incentives that really are the fundamental base of this problem. If you consider a situation, suppose a lender or a servicer is considering a short sale today versus carrying that property to a foreclosure 6 months from now. If the servicer approves a short sale today, its fee revenue for servicing that loan stops today. If they keep that in their books for 6 months, they earn fees for property inspection, broker opinions of value, forced placed insurance, and all of the other fees that continue to accrue until that house is finally sold at foreclosure. When it sells at foreclosure for perhaps 50% of what the short sale price would have been, the servicer suffers no consequence because it doesn't own the loan. The investor suffers the consequence. So the servicer incentives are to block short sales and to keep the property earning a fee revenue for them.
They created a whole industry in Michigan where the thieves and the criminals go into the houses as soon as the house is foreclosed on and the people are thrown out, they see the dumpster roll up. The next day, the thieves go in, steal everything out of the home of any value. And so they leave the home a shell. And the banks still get money because the homes are insured. And beautiful homes that was once appraised at $100,000 plus are reduced to being sold for $15,000 and $10,000 because the thieves went right in and stole everything that wasn't nailed down. So they created a whole criminal industry off of foreclosure and eviction.
Mr. Chairman, it seems to me that we ought to look into the financial incentives in, we've just heard how a foreclosure, people who are doing the foreclosure have an economic interest in getting less money at a foreclosure than they could have at a short sale. Everybody is disadvantaged, and I think there are also some accounting principles where when you realize the loss, that would give people an incentive to just carry this phantom value on the books, creating another disincentive, and I think that's an area we need to look into.
I'd like Susan Jensen and Mr. Park to talk with you and me about the underlying problems that we're actually encouraging the wrong thing to happen in this downturn that we're in, and I'd like to explore that further with you, sir. I'd like to turn now to Howard Coble of North Carolina, but I don't know if he's a chairman-elect of a committee again.
He's a senior member of the committee. We're not sure what his future status will be after January 5th, but I do know that he's been around here a long time, and we're proud to recognize him now.
Thank you, Mr. Chairman. Mr. Chairman, I plead guilty to being a senior member of the committee. That's about all I know with certainty right now, but thank you for that. We'll see. I'll let you know. Stay tuned. Thank you, Mr. Chairman. Good to have the panelists with us. Professor Peterson, let's visit MERS again. What role, if any, did Freddie Mac and Fannie Mae play in the creation of MERS? And what are these entities' current ownership stakes in MERS, if any?
Well, they played a significant role. I think that the origin of MERS was at mortgage banking trade association meetings where they sort of cooked up the idea, and Fannie Mae was a big part of that. I also think that Fannie Mae helped legitimize the agency. This company, people saw Fannie Mae as being part of the government and saw that as, a stamp of approval from the federal government. Of course, there are a lot of things about the GSEs that I really support and think worked well. Everybody disagrees about some of these points, but back in the 50s and the 60s, they really were helping create some home ownership. The GSEs were, but in the past 15 years, I think that they got out of hand and were really became very profit-oriented businesses. And their support of Fannie Mae, in my mind, was because they were trying to shave a few dollars and cents off of their bottom line to help facilitate bigger commissions and bonuses for their management. That's what I think happened. And so I think that Fannie Mae and Freddie Mac bear some responsibility in creating this MERS problem. And at a minimum, we ought to get Fannie Mae and Freddie Mac to stop digging that hole deeper and at least for the time being not purchase any more MERS loans because of the risk that's going to place on the United States Treasury. And currently they are still they still have an ownership stake in the as far as I know, they have an ownership stake in the MERS business.
Thank you, Professor. Mr. Deutsch, several members of Congress have proposed a nationwide foreclosure moratorium in response to the foreclosure documentation scandal. How would such a moratorium affect the housing market?
I think it'd be catastrophic to the housing market. If you ultimately decline or disallow foreclosures to occur in situations where modification doesn't work, a short sale doesn't work, ultimately the capital markets will freeze up. Mortgage funding will no longer flow to new originations of mortgages. First-time home buyers will not be able to get mortgages because, simply put, the capital markets will not put money into a mortgage process if a borrower doesn't pay back that mortgage and they can't exercise rights to the underlying collateral.
Thank you, sir. Mr. Cox, Mr. Kowalski, or Ms. Fluker, either or all of the three, you've testified regarding alleged abuses by servicers in some cases. Courts, however, have procedural rules in place to punish those who swear out false affidavits, mislead the court in one way or another, or engage in other unethical behavior. Why are these mechanisms not sufficient?
Representative Culber, speaking for Maine, we have a state judicial system that is in deep trouble. We have judicial vacancies. We have vacancies in the courthouses. Courthouse hours are being curtailed. The system is simply being overwhelmed. The problem we face is that the court system has enough trouble dealing with its case flow and with a huge increase in foreclosure cases that so far the states have been unable at the state level to deal with this problem. I respectfully suggest there is a solution here in Washington. Attorney General Holder last commented on this issue back on October 6th when he talked about foreclosure irregularities, and he has not been heard from since. And I respectfully suggest that if criminal charges were considered across the country, you would see a significant change across the servicing industry in incentives for getting away with what they've been getting away with. So I suggest that a solution countrywide, because this is a countrywide problem, exists here if somehow the Attorney General's office can be led down this road. I met with the U.S. Attorney in Portland, Maine a month ago to discuss this, and I sense from his feedback to me he's waiting for word from Washington.
Thank you. Either of the other two want to be heard. Thank you, Mr. Cox.
Thank you for your question. First and foremost, so much of this turns not only on just there being the potentially fraudulent or faulty paperwork. I am from Michigan. Michigan is a non-judicial foreclosure state. Therefore, technically, there is no paperwork until the person gets to the eviction stage. You have a sheriff's sale, a posting is put on an individual's house. The first time they actually see any paperwork regarding that foreclosure is when they get to eviction. Eviction hearings in Michigan is handled by the state district courts. It's an expedited hearing. You get the eviction notice. The hearing must be within 7 days of that notice. So literally, you're looking at documentation, if in fact the borrower has representation, which 99.9% of the time they don't. But if they do have documentation, it's only at that point you have the ability to review those documents. And as Mr. Cox indicated, you have an overwhelming scenario with the court system. Many times they're, unable or unwilling because of their caseloads to take the time to literally you're going back and reviewing the whole chain of title. So it puts borrowers at a disadvantage.
Thank you, Mr. Chairman. I see my red light has illuminated. May I hear from Mr. Kowalski? Mr. Kowalski.
In Florida, yes, to answer your question, the state bars are looking at this. Our state attorney general has not been active at this issue, although I understand there's a collection of 50 states attorney generals that are looking at it. But part of the problem in terms of the federal government's response is this. The banks have always come here and said, we do not want to be regulated by the states. We do not want to face 50 different jurisdictions. We do not want the state attorneys general and individual state regulatory agencies to regulate us because we're national concerns. They have come to Congress and said, make us immune under the National Bank Act and other acts, make us immune from the meddling of individual states. And that's what has happened. So as a result, these are national banks. They're regulated by the federal government agencies, and in many cases, the need for transparency, which has been addressed over and over again today, is a federal issue.
Thank you, sir. I yield back, Mr. Chairman.
We've only a few minutes before voting, and I want to divide the time between Mel Watt and Elton Gallagher. Mel?
Do we know how much time we're dividing?
Well,
I'll just take my time, and you cut me off whenever you get ready.
ask the fellow to find out. He's on the phone, right?
Well, they haven't called votes, so we would have at least 15 minutes after they call votes. So I think we can get through in the regular order here. But let me thank my colleague from North Carolina, Howard Coble, for starting down a chain of questions that I wanted to try to pursue related to Fannie Mae and Freddie Mac's involvement with MERS. I noticed that the former administrator of the Federal Housing Finance Agency is here in the room, and maybe he should be at the witness table. But let me just ask Mr. Deutsch, what is your understanding of Fannie and Freddie's involvement with MERS?
I don't have a detailed understanding of the corporate governance relationship with MERS. They are some part owners of the MERS registration system. I don't know the percentage of that ownership, but they are part owners. And
so how could a private registration service take the place of state laws that require establishment of a chain of liens and ownership through title transfer records.
I don't think MERS takes the place of the state laws. MERS operates within the state laws that have been held up and has been held up in a
So
majority
when a mortgage comes to MERS, does it record that mortgage in the state registries?
When a mortgage is originated, let's just say at the very beginning of the process, it will be filed by MERS as an agent, as the owner of the mortgage in the state registry, so that then it can be transferred.
How is MERS an owner of the mortgage
well,
at that point?
they're acting as an agent for the beneficial owner.
They're an agent, but they're not the owner.
Not the beneficial owner.
And when they transfer ownership, if my state requires that be documented on the public records as to establish for everybody in the public, the owner and everybody else, the chain of title, what would happen when that transfers from MERS to somebody else?
Well, a transfer can be effected, and particularly in the capital markets, they're effectuated through.
I'm not talking about in the capital markets. I'm talking about on the state land registry titles.
Right. Well, there's a critical relationship between how it's done in the legal system via contracts and how it's done.
All right. Well, is the former Federal Housing Finance Agency administrator with you?
AFAO Director Falcon?
Yes.
Former AFAO Director Falcon.
Yeah. Could you find out from him while I go on to the next question what Fannie and Freddie's formal relationship with, he is with you, right?
He is an advisor, senior advisor.
Okay. Well, would you turn to him and find out from him while I go on to another question what the Fannie and Freddie's involvement with MERS was at its origination, if he was involved in it at that time?
Sure.
Let me go to another question. This whole thing has been frustrating for me, in particular because I serve not only on the Judiciary Committee but on the Financial Services Committee, which has jurisdiction over the GSEs and the preemption issues that get raised when. So, Ms. Fluker, there's been a lot of talk recently about standardizing these foreclosure procedures by having the federal government take them over. Seems to me that there are some substantial preemption issues involved with that, state preemption, federal preemption of state laws. What is the state of Michigan's state legislature doing is it concerned about this whole process that you've described of non-judicial foreclosures?
First and foremost, I think that it's important to note that specifically with respect to MERS issue, there are quite a few cases up on appeal because it's kind of split. We're a non-judicial foreclosure state. There has not been any discussions as far as changing that structure into a judicial structure, to my knowledge. However, I think it's very important that we realize that it's not an issue of whether the foreclosure is judicial or non-judicial. Is more.
Well, I understand that, but if a sheriff has to make a decision to go and tack something on a door in Michigan, before a court even gets involved in it, that presents a serious problem for that state. That doesn't happen to be the process in North Carolina, and I don't know how the federal government can solve that. That is a state issue. I'm just going to encourage you to, on some of this stuff, you're going to have to push state legislators, because if the federal government standardizes it and preempts all foreclosure laws in the state, I think you're going to be a number of states are going to see their foreclosure laws go down. In your state, you might see them go up, but I mean, I have some serious reservations about federalizing foreclosure law, and I'd say that to all of the attorneys on this panel. My time is up. I would like to get the answer to this first question about Fannie and Freddie's involvement now that I noticed Mr. Deutsch has consulted with his advisor.
For any information about MERS, the ownership interest, you'd have to direct those questions to MERS. Neither one of us are aware of the precise ownership interest, Fannie, Freddie.
Well, you're here representing MERS, aren't you?
I don't represent MERS. They're not a member of the American Securitization Forum.
Okay, so who are you here representing?
At the outset of my testimony indicated those who originate the loans, those who service the loans, the trustees of the loans, the investors in mortgage loans.
Okay. All right, thank you. That perhaps may be the next hearing that somebody has.
Well, I'd ask you to join with me and Bobby Scott and our staff to think about the next hearing, Mel, and I thank you very much. I turn now to Elton Gallagher and recognize him, the distinguished gentleman from California.
Thank you very much, Mr. Chairman. This issue is a particular interest to me. In my former life, I had a real estate brokerage business and have held a broker's license, state of California, for 43 years. And I can tell you in the 20-some years that I was in business before I came to Washington, I had the good fortune of working with a lot of wonderful people over the years, and to the best of my knowledge, I never had a client or a customer that ever had their home foreclosed on. I think a lot of that was due to the fact that times were different, the economy was different, property values were escalating, so even probably the least focused salesmen and brokers could look like a hero because of inflated values. That hasn't been the case in the last several years, and there have been many reasons for that. But I'd like to get back to Ms. Hines and put the human side on this and see how we get into these situations, whether we're dealing with predatory lenders, whether we're dealing with lack of good oversight of the process of brokers and real estate brokers, mortgage brokers, and some personal responsibility. It's my understanding in your testimony, Ms. Hines, that it was you and your sister that inherited the home from your mother and father that had lived in the home for at least 30 years before they passed. Is that correct?
Yes.
And when you inherited the home, was it free and clear?
Yes, it was paid for.
Okay, so the house, they had worked most of their adult lives working their tails off to be able to pay their bills in a responsible way, and you inherited the home. What year did you inherit the home?
In 2006.
2006?
Mm-hmm.
And how long was it after you inherited the loan before you borrowed money?
I think it was 2005.
Okay.
It was 2 years. We went into foreclosure in 2007.
Okay, what year did you get the loan on the how long was it after you inherited before you borrowed money on the property?
About maybe about 4.5 years before we borrowed.
Well, you said you inherited it in 2005?
We inherited it in 2005. Well, my mother died. She's been dead now for 8 years. So 8 years when she died, whatever the time frame, I'm not good with numbers.
You inherited the property about 2002?
Yes.
And in what year did you borrow money against the property?
In 2007.
So you lived there 4 years with it?
My sister and her children lived there for 4 years.
And when did it go into foreclosure?
In 2007.
The same year that you borrowed the loan?
Well, yes. We borrowed the loan the year, I think we borrowed the loan. My sister borrowed the loan 2 years before the house went in foreclosure.
Okay. And did
Let me explain something because I don't want to confuse anybody. My sister was living in a home.
Okay.
I was living in an apartment. So all of the business and she hid a lot of the mail that she received when the house started going into foreclosure from me and my other sister who didn't live in the home.
Now, you said that you borrowed the money to do repairs on the property.
My sister came to us because the house was in dire need of repairs.
So the money that you borrowed probably enhanced the value of the property?
Yes.
Okay. Was all the money used just for repairs?
Most of it, not all of it. Most of the money was used for repairs. My nephew got married that year, and my sister took some of the money and helped with the wedding.
Okay. The reason I ask the questions is because it shows that you're fighting a declining market in value, and you enhance the value, yet you still ended up, as we refer to, upside down. Do you remember offhand what the loan-to-value ratio was when you bought the property? Meaning, how much was it worth?
Was the house appraised for?
No,
how much was the house appraised for? Right. The house was appraised for $80,000.
And how much did you borrow?
We got $43,000.
So it's about 50% plus or minus.
Yes.
And
I would say out of the $43,000 that we received, $40,000 went into the house because we had to have a.
So you spent almost all. So theoretically, you might assume that it increased the value to over $100,000 if you put $40,000 in it.
Yeah, because we had to remove a tree. The basement kept flooding every summer. The basement would flood, and it was because of a tree in the backyard. So we had to remove a tree with the money.
Pardon me, I see the time's expired, and I really didn't want to get off too far on this. I just wanted to show how you got into this situation. I assume there are a lot of people, your friends and neighbors, that are in similar situations.
Well, it bloomed. Once we took out the loan, the mortgage on the house, then my sister was paying $588 initially. And then after a 3-month period, it bloomed to $988. My sister was on disability because she had worked at Cadillac too, and she had incurred asthma and had really a lot of attacks, till they put her on disability for General Motors.
And within 90 days, they increased your mortgage almost 100%?
Yes.
And they didn't explain that to you when you purchased the property, that it was an adjustable after a period of time?
No, they did not.
This was not in the contract anywhere?
It was under a contract, and they gave us a contract. The contract was like 125 pages that we had to read. And so I'm just being honest, we not being lawyers, not thinking that it was going to go from one amount to another amount. And because the house was practically, for the base of the house, we had to have the base of the house reinforced. They call it point and tack.
But I guess my point is I really question how a mortgage could increase 100% in a period of 90 days without the borrower knowing about it. If this was not clearly explained to you and you didn't sign it somewhere, I think there may be another problem here. So, well, you got lots of lawyers.
We got ripped off by a couple of lawyers. We went to a couple of lawyers to help us on the issue, and they ripped us off too. It's just been a nightmare ever since this thing happened. I'm not a financial person. I'm not a lawyer. I wasn't living in a house to actually give you moment-to-moment accounts of what money was spent.
I didn't mean to do that.
No, I know that you're not, but I'm just saying that we went through a lot, and we still going through a lot as a result of being evicted from that house.
Thank you, Mr. Chairman.
Thank you. And Ms. Hines, do you have any idea what a yield spread premium is?
No, I do not.
Okay.
Nor do I.
Okay.
And I don't think my sister does either.
Okay. All right. I will now recognize the gentle lady from California, Ms. Chu.
Thank you, Mr. Chair. Well, as we all know, HAMP fell far short of the expectations. It was supposed to help 3 to 4 million people from foreclosure, but it instead only helped 700 to 800,000. And the Congressional Oversight Panel on that was held in the House cited the Treasury's failure to require servicer participation, failure to hold servicers accountable, and the decision to outsource critical program functions to Fannie Mae and Freddie Mac. And moreover, these programs weren't designed to handle foreclosures due to unemployment. I have a great concern because in California we indeed are facing far more foreclosures. In fact, 1.5 million new foreclosures just in my state alone. And we have created another program called the Hardest Hit Funds Program, which is a TARP-funded program, and it is to be administered by states to assist low and moderate income homeowners and to include principal reduction programs, which several of you have mentioned as being very important, as well as programs to assist unemployed homeowners. But the problem is that not one bank has officially signed on to join this program in California. And so we're encountering the same problems. And I want to ask anybody on the panel how we could get banks to participate in these government-run programs and give true foreclosure relief to hardworking families.
Thank you. I think one of the major things that needs to be done, and it's in my written testimony, and people don't like this word, but it needs to be out there, it needs to be understood. There needs to be a moratorium on these foreclosures. People hear that word, they get scared, they're like, oh my God, these borrowers are looking for a free house. That is not what a moratorium is. This is something that was done during the Great Depression in 25 states during the 1930s. It was upheld as constitutional by the U.S. Supreme Court in Home Building and Loan Association v. Blaisdell. That's 290 U.S. 398, 1934, for people that like to look up cases. And what actually happened was, instead of going to court, throwing people out in the street, people went to court, and the judge determined a reasonable rent for these people to pay. I think that's more than appropriate in this situation, not only because of our economic situation, but due to the fact we have so much underlying predatory and fraudulent conduct coming on. It would allow borrowers to still remain in their home until all of this is sorted out. We can come down here week after week, month after month, but every day that goes by, someone is being foreclosed and evicted, and they're like Ms. Hines, who is not an isolated situation for people to sign these loans and not know that there were adjustable rates. I have senior citizens that have owned their homes 30, 40, 45 years. Documents are brought to them. You're dealing with a broker who's a smooth talker, like, hey, I'm taking care of you. Look, everything's fine. That's why my paralyzed 80-year-old woman in a wheelchair is now facing eviction because she signed a loan for $331, and within a year, it was over $1,400.
Well, I'd like to hear from a variety of opinions. So Mr. Kowalski and then Mr. Peterson.
To start with your question about hardest hit, I read this week, for example, that Treasury outsourced an opinion letter to a banking law firm to issue an opinion as to whether or not the hardest hit funds could go to legal aid groups and HUD counselors to assist with foreclosure prevention. And not surprisingly, the banking law firm gave, I'm not sure why the Treasury lawyers couldn't do this work, but the banking law firm gave the opinion to Treasury that it couldn't. Of course it can. The only system that we've been able to develop in Florida, at least, is a cooperative agreement between the legal services groups, HUD counselors who are properly aware of what's going on with these loan modifications, and pro bono lawyers working with cooperation with the judiciary. The Florida Supreme Court created the entire judicial mortgage foreclosure mediation program, for example. HAMP needs to be strengthened, not abandoned. Maybe some concepts need to be looked at, but it's not voluntary. It's tied to TARP. It was always tied to TARP, and the HUD regulations make it clear it's tied to TARP. And at the end of the day, the servicers are all regulated by the federal government. The servicers make all of the decisions. The servicers decide when loan mods work, when short sales work, when foreclosures are pushed through, and those are all federally regulated entities.
So you're saying it should be tied to the TARP funds?
It is tied to the TARP funds.
Yeah.
We gave them the money, and in return for handing them the money, it was, you've got to go out and work on HAMP.
Mr. Peterson?
One of the problems I see with HAMP is that the incentive that it tries to create to promote modifications, one of the ways it does that is by giving some very modest compensation to the servicer if they succeed and that happens over a staged period of time. But it's not very much money, and it's not a sharp enough incentive to get them to actually do it. So here's a different idea. Instead of having the taxpayers pay money to servicers, a little bit of money to servicers to not foreclose, instead make the servicer or the investor through the trust pay an extra penalty if they actually do go forward with the foreclosure. So switch the incentive. And my advice would be peg it at $15,000. So the first, it called a national emergency homestead exemption. It's short of a moratorium. It's a reasonable compromise. So the first $15,000 in the proceeds of a foreclosure sale goes to the family to help them move on to the next location, get a deposit on the next apartment, pay that first month's rent, get the kids into school. And that money has to be put on the table, cash on the table if they're going to go forward with the foreclosure. It'll give an incentive to borrowers that need that cash in order to move on to stop fighting the foreclosure. It's a lot like the Cash for Keys programs that lots of servicers and lenders have done for generations, where when you're foreclosing, you give $1,000, $2,000, $3,000 maybe to the homeowner if they turn over the keys and turn over the property in good condition without having the fixtures stripped out, that sort of thing. Only the difference is that it's a little bit more money, and it's also clearly signaled to everybody up front. So everybody knows that $15,000 is waiting for them. Lots of homeowners that are in foreclosure don't understand that Cash for Keys is a possibility. So I think that would be, it's an innovative idea, but it's also much more simple than, we don't have to have a big bureaucratic structure that enforces it. It just becomes a federal law. It's a bright line rule. It's very simple and would be effective.
Thank you.
Maybe just want to address briefly Professor Peterson's proposal. Obviously, I think that would create enormous challenges for the pension funds, say a firefighter's pension fund or police pension fund, where now you've created an incentive for a borrower to default because they're paid $15,000 to not actually pay their mortgage. It seems as if that may cause an appreciable increase in the number of foreclosures in America because it's providing an incentive not to pay their mortgage. There are a lot of Cash for Keys programs out there that do provide relocation assistance, where the servicers, when there is no other alternative besides foreclosure, the servicer does help the borrower transition from their home to other places with $1,000, $2,000, $3,000. But to force that upon to the owners of these mortgages, to force them to pay $15,000, will have enormous downstream effects on the future of mortgage lending in America. In particular, because Fannie Mae and Freddie Mac, which is right now on the backs of the taxpayer, because those institutions own such a significant amount of the mortgages in America, it ultimately will then be the American taxpayer who is paying these $15,000.
Yeah. Well, I should cut it off here because I far exceeded my times, so I'll yield back my time.
Thank you. Next we will, and I've been burning to ask this question all day. I think Mr. Deutsch from Florida, you know what my question is, do you not?
Mr. Chair, I think both our witness and myself go by Deutsch, if that's helpful.
Is there any other connection between?
And other than having a last name that is often butchered, I don't believe that we're in any way related.
All right. Okay, thank you. And so at this time, I will recognize Congressman Deutsch.
Thank you, Mr. Chair. But in an attempt to get to know Mr. Deutsch better, I do have some questions for you. And we'll see if these are questions that you're comfortable answering. I wanted to talk a little bit about the securitization process, and specifically the securitization through real estate mortgage investment conduits. Can I continue?
Sure. I'm familiar with REMIC.
Here are the concerns that I have. REMICs, as I understand, receive tax-exempt status. Receiving the tax benefits also, as I understand it, requires strict compliance with the law, including the depositing of collateral within 90 days of the REMIC's formation. Is that my understanding correct?
Correct.
And as I further understand it, the law does not permit fixes to the transfer after that 90-day period. So under this requirement, the only assets that would receive tax-exempt treatment that are in a REMIC are those that are in the REMIC on the startup date.
Correct.
Okay. Now, further, my understanding is that a failure to comply with REMIC law subjects the entity to 100% taxation.
If a securitization trust doesn't meet the REMIC requirements, then the securitization trust proceeds, as they're paid on to the investors, would be taxed as a corporate entity tax.
Right. And if they do meet the requirements, then they're exempt.
Correct.
Okay.
Correct.
Now the oversight panel, the Congressional Oversight Panel that issued its report recently talked about, described documentation standards in the foreclosure process have helped shine a light on potential questions regarding the ownership of loans sold into securitization without the proper assignment of title to the trust that sponsors the mortgage securities. You had said earlier, Mr. Deutsch, that from time to time mistakes do occur. Some of the issues then that I'd like you to speak to include that if the millions of mortgage transfers during the boom, or some number of them, small, large, there may be some dispute, but for those that were not properly completed, then under the REMIC rules, the REMICs may be empty entities that don't own anything. Isn't that correct?
Well, I think the problem with that is that the premise that the trust don't actually loans is invalid.
Okay.
But the trust actually own the loans, and they were validly transferred. And there are abilities for the trust to be able to cure the transfer of those loans once they're in there to perfect the ownership of the loans.
I understand. They may perfect the ownership of the loans, but they can't reclaim tax-exempt REMIC status after that 90-day period.
Once the loans are in the trust, if a deficiency is observed, you have a 90-day period to be able to cure that deficiency.
The 90-day period?
From the time of the discovery of the deficiency.
I'd ask Mr. Peterson if that's your understanding as well of when the 90-day period starts to run.
My understanding is that you can't put them back in after it's closed. After the 90-day window following closure of the REMIC is expired, you can't insert new collateral into the trust. Otherwise, it destroys the tax-exempt status.
Okay, so there's a difference of opinion. The question then is, if they're past this 90-day period, and Mr. Peterson, I'll stick with you for a second. If they're past the 90-day period, and the tax-exempt status can no longer be, it's lost, can't be regained, then what about the next step of assessing liability? Would there be any liability to either the creators of the REMICs? Would there be liability to the trustees or servicers at that point?
Well, you've exceeded the boundary of the competence that I feel most comfortable with. I'm not a tax lawyer, and don't have extensive practice in thinking through what happens when a REMIC status is destroyed. That's a big problem, and it's not something that I've seen before or worked on. So I'm going to be very cautious in answering.
Well, let me just follow that up. Then it's not something that you've seen because the issue hasn't been raised before. Is that the reason?
Well, that's part of it. Yeah, I mean these big securitization deals, there's a lot of money on the line, and the IRS has not been aggressively trying to declare these trusts as no longer tax exempt. In part because I think the Treasury Department has been attempting to prop up some of the financial institutions that would have exposure to those taxes. But I have to qualify this that I'm not a REMIC tax lawyer, so I don't want to. You've pulled me off of my core competence.
I won't ask questions in great specificity. Then I'll only ask again whether you've seen has the suggestion been made that the IRS ought to take a closer look at the tax exempt status?
Yes, that has definitely been made, and who it is that decided not to do that is not clear to me. I assume that somebody high up in the Treasury Department made that decision not to do that. My hunch, my intuition, respectfully, is that there are some compelling arguments that the collateral is not transferred consistent with the Uniform Commercial Code, and there's ambiguity in the state laws out there about how that'll get resolved. There is a credible argument that the tax-exempt status has been destroyed. There has not been case law confirming or rejecting that proposition yet, and it could go either way. And the thing that's scary about it is that it's a closer call than you would think. Having plowed trillions of dollars into this securitization structure, one would think that we'd have that pretty much locked down and certain. It's actually not that certain. There are some decent arguments both ways. What the courts are going to do and what the IRS is going to do, no crystal ball here on the desk from my perspective.
And then finally, Mr. Chair, Mr. Deutsch, have you seen that the suggestion made that some of these REMICs may have lost their tax exempt status, or certainly, given that there's a difference of opinion between you and Mr. Peterson, that difference of opinion, I would imagine, can be found on a larger scale within the industry. Have you seen the suggestion made that it ought to be examined, and is this something that the IRS ought to do, if for no other reason other than to clarify what the correct position ought to be?
I'm aware of 2 academic commentators who have proposed the idea. I think the IRS has a lot of work, and the Treasury Department has a lot of work to do on analyzing and improving the HAMP processes. I think ultimately there is no merit to the argument or suggestion that any REMIC violations have occurred in the $1.5 trillion in private label mortgage securities that are outstanding. I think to follow up on every academic suggestion that something wasn't transferred validly without any proof, and I address this directly in my testimony, both in the written testimony as well as the white paper that we put out just last month, that there is no valid reason to believe that the mortgage loans weren't actually transferred into the mortgage trust.
I understand, Mr. Chair, is my last question, and I understand there may be no reason to believe that. I guess the final question I have is, if, however, there is an example where the transfer was made outside of the 90 days, even outside of the 90 days once discovered, which would call into question the tax-exempt status. In that case, could you imagine the IRS ruling that the tax-exempt status would be lost?
I think what you're potentially postulating is if any individual loan wasn't put into the trust, if there was some mistake on an individual anecdotal loan, if that loan wasn't into the trust, that loan would not be in the trust, but it doesn't destroy the REMIC status of the trust because of one loan's violation.
I'm sorry that we are out of time, Mr. Chair, but I appreciate the time very much. Thank you.
Thank you, Mr. Deutsch, and I will say that this has been a very enlightening and frightening hearing to realize that it's a basic human instinct to want to control, and that control manifests itself in ownership of property. It's sobering to think how far we have gone down the line towards too big to fail entities having rigged up the property ownership process so as to be in a position to attain control of property here in America, land of the free, home of the brave, where a man or a woman's home is their castle. And all of this through private enterprise has been aided and abetted, we're told, by the United States government, by United States government policy or the lack thereof. And we sitting above you, you all sitting down there, we sitting up here, have the power to take this complicated scenario and learn from it, turn it around, and return power and control to the people And so I want to thank each and every one of you for your particular role in the fight. And I'd ask you to not give up hope, to keep doing what you're doing. And I think collectively we will make a difference. I'd like to thank all of the witnesses for their testimony today. Without objection, members will have 5 legislative days to submit any additional written questions, which we will forward to the witnesses and ask that you answer as promptly as you can to be made part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any other additional materials. Again, I want to thank everyone for their time and patience. I hope that, Ms. Hines, you're able to get you another pair of glasses pretty quickly. And I hope your trip back to Detroit is not as eventful as the one this morning coming here. And that goes for all of you all who are traveling. And again, I want to thank everyone for their time and patience. Merry Christmas, Happy New Year, Happy Hanukkah, Happy Holidays, and whatnot. This hearing is on the judiciary, on the committee. This hearing of the Committee of the Judiciary is adjourned.